Suspension and corruption. Article 101 Mortgage. Canon 2059. The first component to a mortgage is a lease formed through the creation of a sestuary vi, trust whereby the higher estate such as a state, territory or nation conveys title to the financial institution as landlord and the borrower as tenant. Leases within a standard mortgage are usually fixed in term, such as 15, 20 years and sometimes for even a longer term. Once the lease expires, the sestuary vi, trust dissolves and title returns to the higher estate. Under modern estate law, a borrower of a mortgage is always a tenant, never an owner. Canon 2060. The second component to a mortgage is a consensual commercial lien issued under estate law whereby a lien is placed upon a real estate deed and title under estate law and a lender is granted certain rights to seize title over the real estate property of the borrower, usually only after foreclosure is granted. Canon 2061. As all mortgages now are commercial liens issued under the estate law of securitized estates, it is now the banks and financial institutions that are legally considered the executors and administrators with the borrowers always considered tenants, whether the loan is fully paid or not. Canon 2062. The third component to a mortgage is the loan, which has two important elements, the principal representing the actual loan itself and the interest, lawfully representing rent of the tenant to the landlord. Canon 2063. Under trust law and estate law, the executives of financial institutions of executors and administrators under estate law are obliged to perform as duty-bound officers of a testamentary trust and not materially alter any conditions of the deed and title which represents a formal will. Deliberate fraud in altering a deed and will constitutes a most grave injury to the whole of estate law of the Roman system and if uncontested and unrepaired is tantamount to the open consent by the most senior executors and administrators of the highest estates that the whole system is now null and void. Canon 2064. The promissory note and application form signed by a lender as part of a mortgage is material to the deed and will of the estate. Therefore, by estate law, any fraud or deception in materially altering the terms of the testamentary trust immediately disqualifies the executive from acting as executor or administrator with the financial institution assuming full liability. Canon 2065. Any inferior Roman court that openly permits the unrepaired and open fraud of trust law, estate law and the law of wills by refusing to repudiate any financial institution that monetizes or multiplies the sale of a loan without consent or remedy to the borrower openly consents that the whole system of Roman trust law, estate law and wills no longer applies and is null and void. Canon 2066. By definition, any property taxes charged by the higher estate to the tenant are the direct responsibility of the landlord. Where a court seeks to foreclose on a property against the tenant and not the financial institution, constitutes a gross fraud is constituted and if unrepaired is an open consent that Roman trust law, estate law and contract law no longer applies and is null and void. Canon 2067. Equity does not exist in mortgage as the terms of ownership is always a lease. Any claim therefore of equity is a fraud and misrepresentation of contract by the lender and higher estates. Canon 2068. The sale of a home or property merely represents an assignment and then novation of lease with most mortgages permitting such conveyance providing the landlord of the higher estate can claim some form of compensation from the sale through taxes. Canon 2069. Providing that a financial institution has not committed fraud against the deed and will of the estate under which a mortgage is applied against real estate, the institution must first seek a granting of foreclosure before seizing the property. This 2.1 form. Article 17 Person. Canon 1498. A person is any valid form attributed to a single member of the Homo sapiens species, or equivalent higher order life form, living or deceased, or to the singular identity of a lawful aggregate of the species. A single member form of person is called person, while a valid aggregate of persons is called a juridic person. Canon 1499. A person attributed to less than a Homo sapien or higher order life form is automatically null and void from the beginning. Attributing a person to an animal, notion or thing is an unnatural and unlawful act. Canon 1500. Only four forms of person are valid, divine, true, superior and inferior. A divine person is the form attributed to a divine immortal spirit expressed in trust, and 2. A true person is the form attributed to a flesh vessel conveyed into a true trust, and 3. A superior person is the form attributed to a valid defined office, and 4. An inferior person is the form attributed by inferior claims such Western and inferior Roman law or Talmudic law. Canon 1501. By definition, a divine person possesses higher standing than a true person and a Roman person has the least rights of all persons. Inferior persons such as Roman persons have no jurisdiction beyond the bounds of dictatorships, militia, and organized criminal enterprises willing to support such false statutes. Canon 1502. The concept of a natural person is an oxymoron and a deliberate corruption of law. Therefore the term is reprobate, suppressed and not permitted to be revived. Canon 1503. Only seven forms of juridic person are valid: supreme, universal, global, civil, mercantile, union and inferior. Canon 1504. An aggregate of persons as a juridic person without at least two active member of the Homo sapiens species ceases to have form. Canon 1505. No aggregate of persons intending to obtain juridic personality is able to acquire it unless competent authority has approved its statutes. Canon 1506. Excluding divine personality, all persons are temporary. Non-juridic persons are extinguished at the death of the associated flesh vessel. Juridic persons are extinguished in accordance with their own statutes and superior competent authority. No juridic person, excluding society juridic persons formed in accordance with Pactum de Singularis Caelum and associated covenants, may exist for more than 100 years. Canon 1507. Representing a juridic person and acting in its name are those whose competence is acknowledged by these canons or by its own statutes. Canon 1508. Upon the extinction of a juridic person, the allocation of its goods, rights and obligations is governed by law and its statutes. If these give no indication, they go to the juridic person immediately superior, always without prejudice to the intention of the founders and donors and acquired rights. 7. Law. 7.14 Corruption of law. Article 325 Settlement, Birth, Certificate. Canon 3347. A settlement certificate, also known as a birth certificate since 1837, is an official document issued to validly recorded poor, paupers, granting them certain basic rights and entitlement to benefits in exchange for recognition of their status as being owned as property and lawful slaves, also known as indentured servants and bondsmen. A settlement therefore is equivalent to a voluntary slave plantation. Canon 3348. Under King Henry VIII of England and his Venetian/Magyar advisors, the first poor laws were promulgated around 1535, coinciding with the first official mandate requiring uniform record-keeping by all Church of England parishes of births, deaths, and marriages. The poor were considered the responsibility of the Church, including ensuring they had ample work and did not starve to death, as they were considered by default the property of the Church. Canon 3349. Under Queen Elizabeth I of England, a set of measures which were introduced which had the effect of accelerating the disenfranchisement of land peasants into landless paupers. Under the Erection of Cottages Act 1588, peasants required local parish permission to erect dwellings, whereas before the erection of a dwelling by a land peasant on their lord's land was considered a right. As a result, the ranks of the landless poor, or paupers, swelled. Canon 3350. Under Queen Elizabeth I of England, the laws concerning the administration and care of the poor were refined through the Poor Law, 1601, which introduced a basic set of rights for the poor as well as the introduction of 2 overseers of the poor, guardian, in each parish, elected at Easter and funded through the first levy, tax, through local rates, now called council taxes, on property-owning ratepayers. Canon 3351. Under Charles II of England, the concept of settlements as plantations of working poor controlled by the Church of England was further refined through the Settlement Act, 1662, and Poor Relief Act, 1662, including for the first time the issuance of settlement certificates equivalent to a birth certificate, passport and social security rolled into one document. A child's birthplace was its place of settlement, unless its mother had a settlement certificate from some other parish stating that the unborn child was included on the certificate. However, from the age of 7 upwards the child could have been apprenticed and gained a settlement for itself through called indentured service, or voluntary slavery. Also, the child could have obtained a settlement for itself by service by the time it was 16. Canon 3352. Under the reforms of the Settlement Act, 1662, and Poor Relief Act, 1662, no one was allowed to move from town to town without the appropriate settlement certificate. If a person entered a parish in which he or she did not have official settlement, and seemed likely to become chargeable to the new parish, then an examination would be made by the justices, or parish overseers. From this examination on oath, the justices would determine if that person had the means to sustain himself. The results of the examination were documented in an examination paper. As a result of the examination, the intruder would then either be allowed to stay, or would be removed by means of what was known as a removal order, the origin of the modern equivalent of an eviction and removal notice when a sheriff removes people from their home. Canon 3353. According to the various settlement acts from the 17th century onwards until the introduction of birth certificates, the issue of a settlement certificate was considered a privilege, not a right. If a peasant wanted to move, the home parish could choose to issue a settlement certificate which then effectively became an indemnity insurance to the new parish if the pauper was unable to earn a living. A settlement certificate was only valid if it bore the seals of the overseers of both parishes and that of the local justices and was not transferable. This is the same model of modern passports for citizens listed as paupers used today. Canon 3354. Due to the increase in the number of poor, in 1723 a new law was passed called the Workhouse Test Act, 1723, in which those who wished to claim benefits and relief as poor now had to enter a workhouse, being essentially a prison for men, women and children, to perform some set work. To ensure that all poor were accounted and could be identified, new laws were also introduced to force the paupers to wear a P on their right shoulders as a mark of their status. This is both the origin of the P still placed as a mark on modern passports and other official documents and the P worn by prisoners from the 20th century. Canon 3355. Beginning in 1773 with the Enclosure Act 1773, followed by the Enclosure Consolidation Act 1801, English Parliament effectively privatized massive amounts of common land for the benefit of a few, causing huge numbers of land peasants to become landless paupers and therefore in need of parish assistance. The Enclosure Acts are the foundation of land title as it is known today. Canon 3356. Because of the deliberate legal theft of land under parliamentary enclosure laws of the late 18th and early 19th century, the number of paupers dramatically increased. This led to the most awful and cruel laws being introduced to deliver to an elite few the slave labor force needed for the Industrial Revolution through the Poor Law Amendment Act, 1834, which effectively stated that the poor could not receive any benefit unless they were constantly employed in a workhouse prison. Thus, despite international treaties against slavery, the very worst slavery being wage slavery or lawful slavery was born, whereby men, women and children lived in terrible conditions and were worked to death. Canon 3357. Beginning in 1834, a number of historic changes were introduced to the record-keeping of births, deaths and marriages, the issuance of documents and the management of the poor. In 1834, British Parliament introduced the Poor Law Amendment Act, 1834, which reorganized Church of England parishes into unions which would then be responsible for the poor in their area and administered by a Board of Poor Law Guardians, also known as the Board of Guardians. The clerks of magistrates' courts still hold the power of a clerk of the Board of Guardians, and 2. In 1835, the Municipal Corporations Act, 1835, was introduced, which effectively standardized the corporate model for towns and boroughs, including making the municipality with elected officials responsible for data collection and service administration, and 3. In 1836, the Births and Deaths Registration Act, 1836, was introduced, which for the first time created the General Register Office and the requirement for uniform records of births, deaths and marriages across the empire by municipal councils and unions of parishes. Thus on July 1, 1837, the birth certificate was formed as the successor of the settlement certificate for all paupers disenfranchised of their land birthright to be considered lawful, voluntary, slaves with benefits provided by the local parish/region underwritten by the Society of Lloyds as it is still today. Canon 3358. Beginning from 1871, further historic changes in the administration of vital statistics such as birth certificates and death certificates with the introduction of health districts or sanitary districts. The Local Government Act of 1871, Public Health Act 1872 and Public Health Act 1875 created a system of districts called sanitary districts governed by a sanitary authority responsible for various public health matters, including mental health, legally known as sanity. Two types of sanitary districts were created, being urban and rural. While the sanitary districts were abolished in 1894 with the Local Government Act of 1894, the administration of the poor is still maintained in part under the concept of district health boards of guardians, including magistrates and other justices of the peace. Canon 3359. Since 1990, under the United Nations and the World Health Organization, WHO, by the Convention on the Rights of the Child, the system of issuing birth certificates as proof of a man or woman being a permanent member of the underclass has become an international system. Canon 3360. One fundamental flaw that remains within the settlement, birth, certificate system for the Roman cult and its agents remains the fact that a settlement certificate is proof that a man or woman must have been born on the land for the certificate to have effect, regardless of convoluted subsequent presumptions of what the certificate actually represents. If a man or woman was not born on the land somewhere, a certificate could not be issued. Therefore, any rejection or return of a birth certificate serves as perfected evidence that a man or woman was born on the land and support to any affidavit of truth concerning their immutable rights from the divine creator. Canon 3361. As settlement certificates and later birth certificates are solely and purposefully designed to disenfranchise men and women from their rightful inheritance through voluntary enslavement and admission to being paupers, The system of birth certificates is wholly without legitimacy, a global system of organized fraud and crime and without lawful effect. Canon 3362. As birth certificates and their use are a deliberate corruption of all forms of law, philosophy of law and application of law, the system is reprobate, forbidden and never permitted to be revived.